Hi, I'm Launi with Learn Law for All, and today we have Howard Dworman with us. Hi, Howard.
Hi, Lonnie. How are you?
I'm great. Thank you so much for being here.
Thank you for having me.
So, a little bit about Howard. He actually started his career as a probation and parole officer at the Michigan Department of Corrections and then went to Maricopa County. And then he went to law school in 2013. And he co-founded the Criminal Law Society in an effort to give back, which I think is really interesting because when you were doing the parole and the probation, I mean, and now you do criminal defense. That's almost like you were on the other side, right?
Yeah, I was. I think what helps me be a better practitioner in criminal defense is I have an understanding of my clients from a different perspective. And I also have the law enforcement background. So when I'm working with law enforcement, whether it be prosecutors or police officers or detectives, I'm able to speak their language, if you will. So I have I think a very well-rounded background that enables me to be as effective as I am.
Yeah, I agree. I think when you're down in the trenches with the people that you're trying to work with, I think that makes a big difference. I think, the background that you have is so different from probably 99.9% of other lawyers.
Yeah, I think so too.
Um, but he did graduate near the top of his class, and he jumped right into criminal law. Of course, that is your background, and he is licensed in Arizona and the Arizona Circuit Court, Ninth Circuit, and the Arizona District Court. So currently, he is a member of several organizations and represents and presents on criminal law, which we just did a great CLE on the Fifth and Sixth Amendments. So if you want more information on that, check that out. So just as the regular disclaimer, listening to this podcast and or watching this video does not create an attorney-client relationship. And I'm only licensed in Arizona. He's licensed in Arizona. And we are not meant to give specific advice. This is for entertainment and educational purposes only. So I do have some questions for you, and it is kind of advice.
Sure,
Because
fire away.
it's really good advice. So I know we talked about this when we were recording, but if you could give one piece of advice to anyone, but my case, I think of kids, teenagers, etc. If you could give one piece of advice to them, what would that be?
In a general criminal sense, is very simple. Keep your mouth shut. Just shut up. Say nothing. I don't mean to sound terribly abrasive or harsh, but it really, I can't tell you how often it is I've had clients where I talk to them, even friends. I represent some friends right now, some teammates from my sports teams, where we talk about these things all the time. And people ask me questions. We're done with the game and we're all hanging out, or my friends will reach out to me and we're just having a conversation. And I tell them, like, just in that situation, don't say anything. And sure enough, a week, a month, a year goes by, and now they call me because they got in some trouble, and we have a conversation. And I said, well, you didn't talk to the police, right? You didn't do any of these things, right? And no, I did. No, I did talk to them. Why? It's just the most blanket piece of advice I can give anybody is to keep your mouth shut. Don't help the state prosecute you.
And let's talk about that because they have the right, and we talked about this in the class. They have the right to remain silent in the event they're being arrested, but they also have the right to shut up at all other times, right?
Absolutely. No one can force you to speak.
So if a cop comes to talk to you and listen, I mean, certainly if you're innocent, you feel like, oh, I can go talk, but no, I mean, I honestly feel like you really shouldn't necessarily be talking at that point, right? Because
Shouldn't.
don't they sometimes get in trouble anyway?
Yeah, well, you're relying on someone you don't know, you've never met before to articulate or to document what you're saying, to interpret what you're telling them. Why would you do that? Why would you ever talk to someone you don't know, let alone shouldn't trust, with sensitive information about something going on that could impact your freedom, and trust them to document what you're saying and to document it correctly and to understand what you're saying? The police aren't going to ask you to do a deep dive into specifics. The police are going to ask you for a 30,000-foot view of what happened, and they're going to fill in the blanks themselves with their own opinions or what they believe that you were trying to say. It's not beneficial. They usually get it wrong, and when they do, we're stuck with it. Moving forward, if you're charged with a crime and you hire a good lawyer, they're going to do everything they can for you to get you out of it, if you will, or to get you the best possible plea. But we're stuck with whatever statements you make. We can't do anything about that. They can be used against you in trial. They will be used against you in trial. And all you can do is try to take the stand and explain your way around it, which now you got the prosecutor basically accusing you of being dishonest, or yeah, accusing you of being dishonest, because now you're accusing the officer who has no vested interest in you whatsoever. They're not the ones there. The police aren't there, with anything to lose, but you are. And so why would the police officer lie? Why would they get something wrong? It was probably you. And that's the way that the prosecutor is going to spin that. Now, of course, we can argue around that, and I could beat up a police officer and say, well, my client didn't really mean that, did he? And go down that road. But at that point, imagine being on a jury and listening to that. And it looks like, a defense attorney doing that typical Hollywood Perry Mason kind of thing where I'm going to get you, officer. You're the bad guy here, not my client. Juries don't respond well to that. People in
Well,
general don't respond well to that.
this reminds me of, and I wish I would have uploaded this even maybe for our class that we just did, but did you watch My Cousin Vinny? Everybody
Oh,
see that movie where it's like, he
love
goes,
that.
and what did he say after that? He said, I shot the sheriff.
Right.
And because he had said, you shot, or not, I shot the sheriff, I shot the clerk or whoever it was.
Right.
And he was asking a question. He's like, I shot the clerk.
Right.
But when it came out, when it was read, he said, I shot the clerk.
Right.
And so it's not necessarily that had he just shut up, that statement wouldn't have come in, right? That statement wouldn't have been there at all. And I think those are the kinds of things that it's not like you are guilty in something. And so you're just shutting up, though that's a good time to shut up also. But even if you're innocent and had nothing to do with it, this person was, tried for murder, and, got into a little bit of trouble because of that. And just because of what he said to somebody that was taken out of context. I look at things, I'm very a rose-colored glasses person. I look at things hoping to find the best in people. That's just who I am. To be a
Sure.
cop, you have to be looking for scary things and the possibility that things are bad and wrong. And that's what they
Of
look
course.
through their
Of course.
cop-colored glasses.
Yep. Absolutely. The police they're going to assume that you did something wrong, and they're going to assume that you're a bad person. So of course they're not looking at it through rose-colored glasses, if you will. And the My Cousin Vinny example is a prime example of that. It's a prime example of even what I'm saying, right? Everyone who's watched that movie, and if you haven't, I encourage you to. It's very entertaining. It's very funny. But it really highlights a lot of these problems. So yeah, in that movie, Ralph Macchio is Vinny's cousin and his nephew, and excuse me, yeah, his cousin, I'm sorry, and is also the suspect. And the sheriff comes in and says, why did you shoot the clerk? And immediately the Ralph Macchio says, I shot the clerk. And it very clearly he's asking a question. Like, you think I shot somebody? He thought he was being arrested for shoplifting, but really, and I'm not trying to take away from the movie here, but really they were being investigated for a murder, for the clerk being shot and killed at the convenience store that they were at. And when they get on the stand, when they get the sheriff on the stand, the prosecutor asks, what statements did the defendant make? And the defendant, and he pulls out his report and says, he said, when I asked him why he shot the clerk, he said, I shot the clerk. And I asked him, yes, why? And he said, I shot the clerk. And I asked him again, why did you shoot the clerk? And he said, I shot the clerk. Now, the way it's conveyed in the trial is if he simply made very unemotional, undriven, I shot the clerk. When in all actuality, when you watch the movie, you will see it's, I shot the clerk?
All right, I got it. I'm going to pull it up real quick.
Sure.
I just pulled it up on my screen. So let me see if I can
Sure.
do that real
Classic
quick.
scene. Classic scene. And it's a prime example of exactly what I'm saying, which is that, this is why you don't talk to the police.
Can you see it all right?
Yep.
Let's talk about that for a moment. You paid for the groceries. And then what?
We went out to the car, and that's it.
When'd you shoot him?
What?
At what point did you shoot the clerk?
I shot the clerk.
Yes, when did you shoot him?
I shot the clerk.
Hey, Dean, we need you out here. I'm in the middle of a damn confession here.
Whoa! Wait a minute!
I asked him if he did it, and he said, I shot the clerk. I asked him again, and again he said, I shot the clerk.
Your Honor, no further questions.
So now, to be clear, because I know we're talking about a jury, there's no jury in that scene. That was the preliminary hearing, the probable cause determination. But again, the sheriff testifies to that during trial. But yeah, the point is highlighted, right? That there's the difference in emotion, how that quote unquote confession was conveyed is exactly, I mean, it's a perfect example of exactly what happens. Just imagine that on a non-Hollywood, much bigger scale where someone's real, life and freedom is at stake. And, I mean, even then it's clear that the person wasn't actually making confession, but that's the way it was documented. And again, right, the sheriff, the police officer, they meet with their person once and they forget about who they are the next day. So
I talk about this in my deposition prep too. If you're talking in a deposition and, someone goes, oh yeah, right. It reads back as, oh yeah, right.
right.
And so it goes from facetious or a snotty tone to just an admission, and agreement.
I've dealt with that in appeals. I've argued many appeals where, I'll argue to the judge how this happened. And the judge has said to me, well, I believe you, that's how it happened, but I have to go off what I'm reading here. I don't get to watch this or see this. I wasn't in the courtroom when it happened. I'm just reading it. And the way it reads is not how you're telling me it happened.
Yeah,
so
and that is why it's so important not to be a snot on the stand too.
Yep.
So I do have another question for you, and I get this one from my clients all the time. If I get pulled over, should I agree to a field sobriety test? Now, just me personally, I just broke my hip, so I couldn't walk a straight line, if someone paid me. I mean, I couldn't do it if my life depended on it. My legs just won't do that. But say I get pulled over and they think I've been drinking or for whatever reason, maybe I was on the phone, whatever it was. What are your thoughts on submitting to a field sobriety test?
Do not do them. Plain and simple, don't do them. They are designed for you to fail, even though the police will tell you it's not a pass or fail. And at trial, they will testify it's not a pass fail. They're just looking for cues of impairment. But don't do them. I've had clients, believe it or not, and you may not believe this, but I assure you it's the truth. I have had 4 clients in my career who had 0 alcohol, 0 drugs in their system. 0. And were still arrested for a DUI because they did those tests.
Wow, so I'm assuming you got the police report. What did they say they failed at?
So again, it's not pass fail. It's just a matter of looking for cues of impairment. So there are a battery of tests that the officers have the person go through. Usually the first is an eye test. It's called the HGN, or horizontal gaze nystagmus test. It's where the police have you follow a stimulus. It's usually a pen or their finger, and they go across a handful of times. And they're looking to see if your eye flutters like the description they use is a windshield wiper on a dry windshield. So they're looking for 3 cues in each eye. There's the walk and turn test where they have you walk a straight line 9 steps down and then turn around using short choppy steps and do 9 steps back the other way. There are 8 possible cues in that test, when really in all actuality there's several more. There could be 1 for each step and then 1 for the turn and 1 for the instruction phase, but they just narrow it down to 8 of them. The 1-leg stand test, where the person has to stand on 1 leg, keep their foot 6 inches above the ground. There are 4 cues of impairment on that test. There's the Romberg modified, which they have you stand. Police will have you stand with your arms out, your head tilted back, your eyes closed, and estimate the passing of 30 seconds. And in that, there's 7 cues to look for. There's the finger to nose test. And the finger to nose test, I believe, has 7 or 8 cues of impairment that they're looking for. So all those battery of tests, it's not a matter of passing or failing. It's a matter of, do you show enough signs or symptoms? For the HGN, the eye test, they need 4. For the walk and turn, they need 2 out of 8. 2, that's it. For the 1-leg stand, they need 1 out of the 4. The finger to nose and the Romberg modified, those are not validated tests. So even if you participate in them, they're not going to be used against you in trial, but they can still be used to develop probable cause, because all the officer is trying to do by having a person go through field sobriety testing is to establish probable cause to arrest. They don't care if it can or can't be used against them in trial. They don't care if it's evidence of a crime or not. They just care that it shows that there is some evidence the person may have committed a crime, and that gives them the ability to arrest the person. That's all they're doing. Not doing those tests makes it a lot harder for the police to arrest you, makes it a lot harder for the prosecutor to get a conviction against you. Now, given chances are, if the police have already pulled you out of the car and they're asking you to do those tests, they are intending on arresting you anyway. Don't make their life easier. They're probably going to arrest you based off of the driving behavior and an odor of alcohol or odor of drug that they notice or smell, or an observation they make. Let them arrest you. It's going to happen. You can't fight it. You can't talk your way out of it, but do not help give them any more evidence against you.
What if they say they want you to like blow into the breathalyzer?
Breathalyzer? Yeah. So that is a field test. If the breathalyzer is done in the field, refuse it. When you get to the station, and again, this applies to Arizona, I'm pretty sure almost every state has an admin per se implied consent law. Admin per se is that it's administrative on its face, that your license will be suspended so long as you consent to a test of your breath, blood, or urine, or other bodily substance. Implied consent is a 1-year suspension. Essentially it's implied based off you obtaining your driver's license in the state of Arizona that you are consenting to a test. And because you're refusing that test, you've violated your agreement with the state. Arizona will suspend your license for a year. And these, of course, apply to first offenses. If there are second or subsequent offenses, those penalties become more severe and more harsh. But nonetheless, an admin per se suspension in Arizona is 90 days, and an implied consent is 1 year. And certainly talk to an attorney about how to handle those and manage those, because there are ways to, I won't say avoid the suspension, but there are ways to curtail it or to minimize the impact it has on your ability to operate a motor vehicle. So
if you're sober, you shouldn't blow into it, or if you're drinking, you shouldn't blow into it, or I mean, eventually you have to submit to blood, right? If you don't want your license suspended.
If you don't want your license suspended for the 1 year and you just want to do the 90 days, yes, you will have to, and any good attorney will advise a client. Well, I shouldn't say that. I don't like to speak in absolutes. There may be situations where I will tell my clients, don't submit to the test, don't consent to it, just let them get a warrant. They're going to get a warrant. So either way, they are going to draw your blood. They cannot force you to blow into an intoxilizer down at the station, but they will usually ask you to do that as well. Listen, if you haven't been drinking and you don't have any drugs in your system, my advice is still don't do it. But yeah, if you are that confident and you're okay with running the risk that you might have to hire a lawyer to deal with this later, then sure, go ahead and participate in the test. But for the most part, my advice is a blanket advice is to not participate in any of those tests, but to submit to the blood test when you get to the station. Don't do the breath test when you get down there. I've never seen anybody have to do a urine test or a hair test or anything like that, or a swab test, if you will. But I suppose it's possible they could ask you. The only one you should agree to is blood. A lot of police departments will tell you that you have to agree to all of them. And if you don't, they're going to document it as a refusal. That's fine in a grand scheme of things. And this, as blanket advice, I will say, talk to an attorney first, because you may have to articulate why you can't do a breath test. For example, I've had one client who couldn't provide a breath test because she had lung issues, and she wouldn't be able to take that deep of a breath and blow for that long without causing her some medical compromises. So, that's just one example of a reason that people tell the police, I can't do the breath test, but I will do the blood test. And that way you still get the consent and you don't have to deal with the 90-day suspension instead of the 1 year. But anything that the police ask you to do on the side of the road prior to being taken into custody in any shape or form, you should refuse.
And then, okay, just to be clear, because I think I might have got it mixed up in my head. So if say I get pulled over, and I refuse to do anything on the side of the road, and I get arrested, do I automatically lose my license for 90 days or a year, or if I submit to the blood test, then I don't necessarily.
Well, so it's not necessarily automatic. The police will explain to you and they will give you the admin per se implied consent form that you can request a hearing. You have 30 days to request a hearing. That request will also stay your suspension. So until the hearing happens, your license remains valid and in place and totally intact. Once the hearing occurs, that might change depending on if the state proves their burden, and the suspension should be upheld, or if the officer doesn't show up and they can't meet their burden, maybe the whole suspension gets voided completely. And then the only time that you get suspended is the admin per se upon conviction, if the person's convicted of DUI. So there's a lot of layers to peel back here. But in a general sense of the word, or general sense of the advice, I would say if you get pulled over for DUI and they do get arrested and you do get the paper license, the admin per se license, request the hearing within 30 days. And that way your suspension is stayed until the hearing takes place. Now, I do those things in my practice. That's part of what I offer in my services is I handle that for my clients. I will send out the request for hearing and stay and make sure that those things are done and that they're put in place. So my client doesn't have to worry about any of those things and can just continue on with their life as if nothing's going on. But that's,
So what does that hearing look like? I mean, if they signed it, and they didn't do what they were supposed to do, what are the chances that they don't lose their license?
I'm not sure I understand the question exactly. So you're saying to me, if the person refused the field sobriety tests and they didn't have anything in their system, but they consented to the blood or breath test, right?
Correct, yes.
Okay. So in that case, if they consented to the breath or blood test, there's only a 90-day suspension. Part of the elements for that hearing are, should the person have been arrested for a DUI? So if the state can't show that the person had a blood alcohol content of 0.08 or above, or a drug in their system that's precluded by statute, I can move to void on that issue alone. It's different for the implied consent hearing. So the implied consent hearing is, was the person arrested for DUI and did they refuse the test? The lawfulness of the arrest isn't quite a matter of question for the implied consent hearing. It's only a matter of question for the admin per se hearing. So it's delicate. And that's, if a person knows for sure that they have nothing in their system, then go ahead and consent to the test at the station, and then we'll deal with it later with the admin per se hearing. But for the implied, if it's implied consent, it doesn't really make a difference whether there's anything in the system or not. So they really should consent. I've got a case right now, one of my teammates actually, from hockey, who BAC was a 0.02. So the legal limit in Arizona is a 0.08. He was significantly below that. And I was able to keep the criminal case from being charged at all. I talked to the prosecutor and the police officer. His case isn't being charged criminally anymore. That's a done deal. But he refused the test. So we still have a pending implied consent hearing coming up. He could still lose his license for a year simply because he didn't consent to the test, even though he arguably didn't do anything wrong, at least not from a criminal standpoint. But the MVD is an administrative body. You are entitled to due process for a driver's license. It's any license that the government gives you. You're entitled to due process before they can take it away, which is notice and a hearing. But the rules that garner that hearing are totally up to the MVD, and they've established, these rules that, for example, if you refuse, you lose your license.
I mean, that seems scary to me. So what is
Yeah.
then the benefit of it? What is the benefit of refusing if you don't have it in your system?
Well, the benefit of refusing if you don't have it in your system, there isn't much, other than you don't want to just give evidence against yourself if you don't have to. But usually a lot of times where I have clients that I will advise them to maybe refuse the test is, say that the person is accused of DUI that involves a collision, and that collision resulted in the serious physical injury of another person or even their death. It happens frequently. I have a handful of cases like that right now. It's very sad. In those situations, I might tell my client, the longer you wait, the lower your blood alcohol level is going to be. So refuse, delay as much as possible, do what you can in order to help, give exonerating evidence against yourself, because you're going to give evidence against yourself regardless, but, lower that blow a little bit. Excuse me.
Right, so if they wait to get the blood draw and it takes 2 hours to get it there, find a phlebotomist and draw the blood, maybe their alcohol level goes down from 0.08 to 0.05.
Sure. And
Okay,
that would be a huge help to my client because then we get into presumptions. In Arizona, there's jury instructions on presumptions. 0 to 0.049 is there's the presumption the person's not impaired. 0.05 to 0.0799, there is a presumption. There are no presumptions, but the jury is free to presume the person could or could not be impaired. It essentially is saying there's reasonable doubt here. And then 0.08 or above is the presumption the person is impaired. That's a universal level of impairment. So in that situation, while impairment isn't necessarily going to be a major contributing factor to the prosecution on an aggravated assault or a murder investigation or a homicide investigation for that matter, it certainly helps to be able to turn to the jury and say, have an expert testify that they could be presumed not to be impaired. And this really was just an accident, not a matter of somebody being reckless or negligent or intentional. And of course, we're going down a rabbit hole a little bit here, so I'll stop there. But
yeah, I
certainly,
was thinking this would make a whole nother great CLE.
yeah, oh yeah, I'm sure it would. And certainly, if anybody wants to talk to me about those things or ask me any questions, I'm happy to answer any questions I can. And I say what I can because I don't pretend to know everything, and I'm not going to know everything. But I have a lot of resources in the community. If there's something I can't answer, I can get the answer for you.
Well, I really appreciate you being here. I think these were really great answers, and anyone who wants to see the full video can, there'll be a link on this to Learn Law for All, and also there'll be Howard's contact information will be available also below. So if you have any questions, please feel free to call, reach out to him. Attorneys, if you're not practicing criminal law, there are a lot of times where we need criminal lawyers or to at least have discussions or send our clients to. So, please feel free to reach out to Howard. He's been so great and easy to work with. I really appreciate you.
Thank you. Absolutely. I'm happy to answer any questions. Anybody wants to reach out, don't hesitate.
Thanks.